Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled Maritime Law, Singapore Carriage of Goods by Sea Act and the Fisby Rules. So this is the fourth part of the video. First, scope of the Fisby Rules. 25.4.18 Under the Carriage of Goods by Sea Act of Singapore, the Fisby Rules have the force of law in Singapore. Pacific Electric Wire and Cable Co. Limited v. Neptune Orient Line. The HVR apply to every bill of lading relating to the carriage of goods between ports in two different states. If the bill of lading is issued in contracting state of the HVR of the carriage is from in a port in a contracting state, or the contract contained in or evidenced by the bill of lading provide the rules of legislation of any state giving effect to the HVR are to govern the carriage. 2. The HVR only to contracts of carriage covered by a bill of lading of any similar document of title. 25.4.19 The HVR applies only to contracts of carriage covered by a bill of lading, including a straight consigned bill of lading or any similar document of title insofar as such a document relates to the carriage of goods by sea. The HVR apply to the period from the time when the goods are loaded on board the ship to the time are discharged from the ship. 3. The carrier is bound to exercise due diligence to make the vessel seaworthy before and at the beginning of the voyage. 25.4.20 A carrier is bound to exercise due negligence to make the ship seaworthy before and the beginning of the voyage. The obligations under the HVR exercise due diligence to make the ship seaworthy replaces the absolute obligation at common law to provide a seaworthy ship, subject to the provision conferring protection on a carrier in certain circumstances. The carrier is obliged under Art. 3. Rule 2 of the HVR to properly and carefully load, handle, stow, carry, keep, care and discharge the goods carried. The carrier enjoys baggage and weight limitation in addition to the exclusion under Art. 4. Rule 2 of the HVR. 25.4.21 A carrier enjoys baggage and weight limitations of 10,000 gold French per package and 30 gold French per kilogram under the HVR. There is also a list of exclusion under Art. 4. Rule 2 of the HVR, which a carrier may avail himself of, provided he satisfies the obligation of exercising due negligence to provide a seaworthy vessel. 5. The carrier is discharged from all liability in respect of goods carried under unless a seat of brought within 1 year of the delivery date, but this period may be extended if parties agree. 25.4.22 The carrier is discharged from all liability whatsoever in respect of the goods unless a seat is brought within 1 year, the date of delivery or the date when the goods should have been delivered. The 1-year period may, however, be extended if the parties so agree after the cause of actions has arisen. The limits of specified DHVR may not be reduced further for the carrier's benefit. 25.4.23 The exclusion, the time limit and limitation of liability prescribed by the HVR may not be reduced further for the carrier benefit. F. Jurisdiction or arbitration agreement in contracts of carriage. 1. A jurisdiction or arbitration clause might be incorporated into a contract of carriage. 25.4.24 A jurisdiction or arbitration clause may be incorporated into the contract of carriage whereby the parties agree to specific volumes of the adjudication of dispute arising out of the contract. Nonetheless, parties may be tempted to breach such jurisdictions or arbitration clauses so as to take advantage of certain time for difference on higher limits of liability that may be available in volumes of than those agreed in the contract. Where such breaching happens, the defendant can apply for a stay of the proceeding. 2. The court will prima facie give effect to foreign jurisdiction clause, but may refuse an application for stay where the facts and circumstances are exceptional. 25.4.21 Where the contract contains a foreign jurisdiction clause, the court will prima facie give effect to it, but it has the discretion to refuse an application for a stay if the facts and circumstances are so exceptional as to amount to a strong cause to warrant such a refusal. In determining whether strong cause is established to refuse an application for a stay, the merits of the defense are irrelevant, but it is not settled as to whether this provision applies to bills of lading and standard from contract where the plaintiff was not in a position to negotiate. 3. The court retains discretion to stay proceeding in favor of domestic arbitration, but must grant stay in favor of international arbitration. 25.4.26 Where there is an arbitration clause, the court will generally give effect to it. In cases governed by the Arbitration Act, the power to stay is discretionary, as a stay might be refused if, for instance, the claim is clearly indisputable. However, under the International Arbitration Act of Singapore, a stay of claim falling within the arbitration clause is mandatory. The court has no discretion to refuse to stay in the action. Once the court is satisfied that there is an arbitration agreement between the parties and that the proceeding instituted in court are in respect of a matter that would be subject to the agreement, the court will be ordered a stay. A court is entitled to order retentions of any vessel under arrest of any security furnished to facilitate release of a vessel provision or equivalent security for the satisfaction of any award under S7 of the International Arbitration Act if the actions stay under S6. So the sections 5 admiralty law will be explained or will be read in the next video. So don't forget to watch the previews and the next video, and bye bye.